remind everyone to please turn off any cell phones or anything else that might ring a register. All rise. Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. Good morning. We're here for oral argument in cause number CV120766, Focus Point Properties and Jeff Cantor versus Cleo Johnson and Oak Acres Trust. These proceedings are being audio and video recorded, so please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellants will be responsible for reserving any time that they wish to keep for rebuttal. We have read the briefs and have conferenced this matter, and we'll look forward to your argument. You may proceed.
Good morning, Your Honors. Patricia Primo on behalf of Cleo Johnson and the Oak Acres Trust, the appellants in this matter. We bring to you an appeal that is unusual from the cases you probably see up here on a day-to-day basis. We recognize that we are appealing following a jury trial and a jury verdict that found in favor of the appellees and against my client, Ms. Johnson and Oak Acres Trust. We do believe that there's a significant legal issue that was improperly decided at the trial court level, however, and that has to do with the interpretation of ARS 22-2152. The key aspect of this case is distinguishing the Arizona Department of Real Estate's exclusive authority to discipline, suspend, or revoke a real estate license under 2153 versus the mandate that the court make under 2152 in determining whether a real estate licensee is qualified and therefore should be entitled to enter the court system in order to collect money for a commission. The findings by the trial court judge in this case were very clear. There is no dispute, no factual dispute here, that Mr. Cantor violated numerous statutes governing licensed real estate agents, violated the Arizona Administrative Code regarding licensed real estate agents, as well as violating a consent order in which he vowed to the commissioner of the Department of Real Estate that he would abide by certain conditions. Those facts are undisputed that Mr. Cantor violated the terms of the consent order. He was supposed to abstain from drinking, yet he continued to drink. He obtained another DUI, yet failed to report that DUI, when the very purpose of this consent order, the heart of it, was not just 2 prior DUIs, but his failure to report the first 2 DUIs. And when asked by a juror in this case at the trial court level, why didn't you do this? Well, the answer wasn't satisfactory to the jury. It certainly wasn't satisfactory to Judge Fink. He expressly said in his minute entry denying our motion for new trial that Mr. Cantor, his conduct was reprehensible, that it was a flagrant violation of the trust that the Department of Real Estate's commissioner had placed in him, but that the trial court felt that its hands were tied.
Well, let me ask, if they had negotiated a sale with a third party, the sale had gone through, could the third party come in and say, well, this man should not have had a real estate license, this whole transaction should be set aside?
Your Honor, 322152 specifically addresses the ability of a real estate licensee to come into court to sue for that commission. The statute does not address an outside party trying to come in and set aside a real estate commission. So in other words, by bringing this lawsuit, as Mr. Cantor did, he had the burden of proving that he was a qualified licensed salesperson. And it is our opinion that rarely will a trial court be faced with the facts that we have here. It is not asking the trial court to hold any sort of a mini hearing. And in fact, the fact that we do have the word qualified in the statute, if all Mr. Cantor had to do was be licensed, the statute would say you have to prove that you're licensed. The court or the legislature asked the courts to go beyond just the licensing and say, but are you qualified? And we go back to that Farragut case where the court did impose a broad interpretation of 322152. The facts are very different. We had someone who was licensed, then there's an interim period where they're not licensed, and then they go with another broker, they get their license back.
But why isn't that the controlling fact, that the absence of a license? Why shouldn't we just look to whether someone is licensed at the time the transaction occurs?
Because in the Farragut case, Your Honor, what the plaintiff, what the real estate licensee tried to argue was, under the literal terms of the statute, I was licensed when the cause of action accrued. I was licensed when the deal was signed, and I didn't earn my commission until the deal was signed. That's the very argument the real estate licensee was trying to make. The Court of Appeals said, wait a minute, if we accept that interpretation, then real estate licensees can just go out violating the law by acting as a real estate licensee without a license, and then slip in and get their license in time to be able to consummate the deal and get the commission, and that would circumvent the very purpose of the real estate licensing statutes, which, as we are all aware, nobody disputes, is to protect the public from unscrupulous licensees. I use that as an analogy to say, here is what the trial court has allowed as well: a toothless application of 322152, because what it allowed Mr. Cantor to do, there's not an interim suspension here as there was in Farragut. Instead, there was just a couple of years of a flagrant violation of a consent order that required him to refrain from alcohol, that required him to be law-abiding. There was a flagrant violation of his duty to self-report under the administrative code. There was a flagrant violation of his duty, literally doing a jail term for 30 days while holding his real estate license and not saying anything about it. And the toothless application in this context is, well, as long as you don't report yourself and you violate the law and nobody catches you, you can continue to collect real estate commissions because nobody's complaining about the transactions until something goes wrong, until you get caught. And then, okay, now that you don't have your license, you're not going to get commissions moving forward. But in the interim, we do have a real estate licensee committing crimes of moral turpitude. Again, I point to Judge Fink's language that we quoted extensively in our brief about the sheer contempt that Mr. Cantor had in this situation. We're not asking the panel to revisit the jury's determination. It is interesting that even Judge Fink said, I doubt if other juries would reach this conclusion, because when we talk about the breach of fiduciary duty, we're also talking about failure to explain it at the time the document was signed, the new listing agreement, signing it on the trunk of a car in a parking lot, signing it outside of the presence of Ms. Johnson's attorney. I mean, even Judge Fink was going, you know what, I'm not sure what I can do with that. Our second argument on appeal is, if you take those facts as undisputed, can you really make a determination that there was sufficient credible evidence to say that that, as a matter of law, satisfies a fiduciary duty? The case law specifically says a duty of a real estate licensee is to protect the interests of its client, to explain documents that are being signed, to provide copies that are being signed. But candidly, Your Honor,
wasn't there testimony that he said he explained the document?
there was hazy, to quote Judge Fink, hazy testimony,
That's
that
the hurdle you have to climb.
And that is the
climb over
hurdle.
here, isn't it?
That is the hurdle on appeal that we have. Our primary issue truly is the importance of the vast authority that this state gives to real estate licensees, that they are given authority by the Arizona Constitution and be given the ability to practice law in a limited sense in exchange for their agreement to abide by the licensing requirements, to abide by the Department of Real Estate and what they're ordered to do.
So how would a court, not necessarily in this case, but just sort of hypothetically, how would a court go about evaluating whether a licensee real estate agent was qualified in a particular case? And so tell me how that would work. Would the opposing counsel be able to start checking the records, coming in with traffic citations, criminal records? I mean, what would be the foundation for that hearing on to determine whether somebody was qualified?
Thank you, Judge Brown, because that is an excellent question. And I think, again, we're talking about a very limited set of facts. We have case law cited throughout the brief that says you can't collect a commission if you, in order to do so, you are violating the law. So it's not, are you a good real estate agent or a bad real estate agent? It's, have you complied with the laws that are required of a real estate licensee? So it's very limited. If somebody has a DUI and they report it to the Department of Real Estate, there's no issue because they've self-reported. And I don't care whether it's a DUI or shoplifting or fill in the blank of any, quote, violation of law.
Aren't you suggesting, though, that if they self-report and for whatever reason the board decides not to suspend their real estate license, then you're suggesting that there is no argument that the realtor would be entitled to a commission?
If it went through the full process, which is not what happened here. If it went through the process and you self-report and the Department of Real Estate says, you know, thank you for self-reporting, we appreciate your candor, and we're going to, for example, give you a provisional license. That's what happened to Mr. Cantor here initially. It was a provisional license. That doesn't mean that person's not otherwise qualified because they are complying with every single statute, administrative code, and order of the commissioner. That's a very bright line to
That
decide.
suggests to me, though, that notwithstanding someone has committed a crime and done something that makes them unfit, theoretically, to hold a license, if the real estate board decides that they're not going to suspend their license, that seems binding from our perspective. And so I'm puzzled as to how we can make the determination independent of what the licensing agency determines.
And Your Honor, the Department of Real Estate determines whether or not somebody should hold a license. 2152 is a different standard as to qualified, and that authority specifically is in the context of a licensee bringing a legal action for a commission, and the statute specifically requires that the court shall determine whether they're qualified. And so in that instance, again, what we're specifically looking for are violations of real estate licenses, statutes, administrative codes, consent orders. The concern here, which again I think the facts are very limited and not likely to come up very often, would be the circumstance. In an ideal world, once this issue was raised, the trial should have been stayed to allow the Department of Real Estate to finish its determination. Ironically, 1 month before trial, Mr. Cantor voluntarily surrendered his license. He surrendered it with the understanding that he will never, ever again be able to hold a real estate license in the state of Arizona. Now, although Appelli argues that, yeah, but couldn't the Department of Real Estate still continued its own, proceeding against this? And as a practical matter and with the state's resources, once you have a consent that says, I'm never going to subject any harm to the public as a licensed real estate agent, the resources aren't there, nor is there clarity in the law as to whether there needs to be that determination. That's why we looked to the judge, to Judge Fink, to be able to say, look at the undisputed evidence. The undisputed evidence here was the violation of statutes, administrative code, and consent order. And we maintained that 2152 mandated that the trial judge make that determination. At a minimum, we would ask that the matter be remanded in order for Judge Fink to be able to make that determination, but I don't think that Mr. Cantor should be able to escape so easily by just surrendering his license a month before trial and then coming in the following month to the courthouse and demanding $140,000.
Counsel,
yes.
I'd like to ask you to move briefly to the argument that Ms. Johnson should have no personal liability.
That is a huge issue, Judge Brown. Thank you, because I'm so focused on my
And I want to ask you
statute.
specifically, just to cut to the chase, is what efforts, if any, were made to remove her from the litigation? And secondly, in that same context, isn't it true that she brought counterclaims in her name along with the trust, and therefore doesn't that sort of shut the door on any assertion that she should not be held personally liable?
Your Honor, the answer that was filed in this case stated that Ms. Johnson signed as trustee, not in her individual capacity. As a legal matter, since she owned the property as trustee of the Oak Acres Trust, there's only one capacity that she could legally be held obligated under the listing agreement.
In what capacity was she bringing claims in her individual capacity? Why would she be entitled to bring claims in her individual capacity if that's the argument?
Including a vulnerable adult claim.
Because candidly, we felt that Ms. Johnson, as a vulnerable adult, was taken advantage of through the situation, but we did not plead it as trustee of the Oak Acres Trust.
And then in terms of Judge Brown's first question, in the trial court, what objections were made to the jury instruction asking the jury to decide this issue? Or what efforts were made to remove Ms. Johnson individually?
Your Honor, we did move, when we were discussing jury instructions, that as a matter of law, that Ms. Johnson be removed because she could only sign in her capacity as trustee of the Oak Acres Trust. If she had signed in her individual capacity, there'd be a separate lawsuit saying she didn't have authority to bind the trust. The judge allowed that question to go to the jury.
Okay, so you did object to that?
I did object. It went to the jury. And, Your Honors, if I may, I'd like to reserve the balance of my time for rebuttal.
Thank you.
Thank you.
Good morning, Your Honors. My name is Tim Thomas, and I represent Jeff Cantor and Focus Point Properties. As you all know by now, that this was a suit to collect a commission. It was defended basically on the grounds of fraud and breach of fiduciary duty, and also, of course, the contention that Mr. Cantor couldn't bring this case because he was not a qualified salesperson. It was tried to a jury, and Mr. Cantor and his broker prevailed. The jury found that Mr. Cantor complied with his fiduciary obligations, that he did not defraud his client, and all of the information about his qualifications were all presented to the jury, and they simply rejected Ms. Johnson's position. In fact, the jury even awarded punitive damages without finding fraud, and of course that part was set aside. I think we've got here a pretty clean legal issue, and that is simply the question of, does this statutory scheme vest jurisdiction, if you will, in the Superior Court to determine independently whether or not somebody who is a salesperson is qualified? And, Your Honors, I think the answer to that is clearly no. When you look at this statutory scheme, what you have is a scheme that exclusively vests jurisdiction with the Department of Real Estate on issues about suspension and revocations. And the case law holds, the Howard case, for one example, is whether or not a court would agree or disagree is not the question. It is up to, unless there was some extreme circumstance or absolutely no evidence, it is up to the Department of Real Estate to determine whether or not it is going to suspend licenses or discipline salespeople. The statute simply does not allow, I guess, competing jurisdictions, if you will.
Counsel, go ahead.
I think this would be a very clear-cut case in your favor if the statute omitted the word qualified. If it said to commence the action, the complainant shall allege that the plaintiff was a licensed broker or salesperson. We'd clearly have little to talk about. So what does that word qualified mean? And then the next sentence says, prove the alleged qualifications in court. How should we interpret that word?
I think you're exactly right, Judge, and I can't go back and figure out exactly, obviously we don't have any indication of what the legislature was intending here. But what I can tell you is when you look at the statutory scheme as a whole, and I think that's what you have to do in determining what the intent here is. The statutory scheme as a whole did not intend for there to be mini trials, if you were, as to what qualifications were. I attribute this to sloppy draftsmanship in the statute. I just don't think when you look at the scheme as a whole, there was an intent to have judges make decisions as to whether or not somebody was qualified or somebody was appropriate licensed.
Counsel, isn't it significant, though, the legislature chooses to put a sentence in that says prior to hearing the action, the court shall require? I don't know if you're aware. I'm not aware of, or nothing jumps out to me of any other circumstance where it says prior to going to trial, the court shall require this threshold determination. So it seems a little bit strange that the court's going to be required to see the certificate. Mm-hmm. Bring the certificate in. I got to see it, and then we're good to go to trial. This seems a little bit strange that the legislature would go to those drafting pains and then for the purpose of seeing a certificate.
Yeah, I agree with you. I mean, and again, I think that I don't think that when you look at this scheme as a whole, though, the intent was to have a judge sit there and decide whether or not the person is qualified. I mean, there's no indication of what the standards would be, and the real conundrum would come up. What if you had competing decisions? You had a proceeding in front of the Department of Real Estate, and the Department of Real Estate decided not to suspend or decided that the person was qualified, but now the Superior Court disagreed with that. I don't, again, when you look at this scheme as a whole, there's absolutely no indication that the legislature intended for that issue to be vested with the Superior Court. And in fact, Your Honors, when these things come up, what typically happens is, in these types of cases, is you just prove that you're licensed and that's it. And not that that's determinative by any means, but that's what typically happens. You have to present and establish to the court that you are licensed. And practitioners refer to this statute as the statute that requires that you be licensed in order to recover a commission. And you know, you start thinking about what would a trial judge, what basis would he have? What standard would he have for making this decision? And if we allowed that to happen in every, you can just imagine, in almost, I'm going to say every case, but almost every case, you'd have people coming in and they'd be trying, who didn't want to pay their commission, trying to find anything that they could to allow the judge to say you're not qualified, or say he didn't do a good job for me, or she didn't do this, or she didn't do that, or he had a traffic conviction 3 years ago, etc. That's simply not the type of proceeding that the legislature intended here when you look at the statutory scheme as a whole. In fact, when you look at the arguments in the briefs here, what we see time and time again is the argument, I think, acknowledging the difficulty with this jurisdictional issue, and I think that the appellants acknowledge that, well, yeah, this really is a department issue when they say things like, well, there was a basis to revoke. There was. And they even say, well, it was obvious that if the department had had this information, they would have suspended his license. All those arguments do is establish, in fact, there might have been a basis, and that might have happened. But those are speculative, and in point of fact, it didn't happen. It certainly could have. And when the department ultimately found out about this, they could have continued their investigation when Mr. Cantor turned in his license. They could have continued that. They could have issued some other type of discipline. I don't know why they couldn't have retroactively suspended his license, but they chose not to do that. They were satisfied when he turned his license in and took no further action. So, Your Honors, at the end of the day, the issue is, who has jurisdiction to make this determination? And it is the Department of Real Estate. It is to have the exclusive jurisdiction. It has the standards. It has the means to make this decision, and they do it all the time. And it was not one that was vested with the trial court. I want to address briefly the second issue. It's an independent issue, this issue of illegality. And it is a separate issue. In the cases and talk about the fact that there's an independent issue here as to whether or not the broker was acting illegally. And I think that it also certainly provides a litigant with a second kind of opportunity to make the same kind of argument, but it's a little bit different. And it certainly goes beyond the issue of license, because the cases talk about the fact that the broker cannot base his commission on an illegal contract. In other words, if he was not licensed at the time the contract was made, or not licensed at the time he was engaged in the acts, he still can't recover, even though he may have had a license when the cause of action accrued, which is what the statute deals with. And this issue, though, although brought in the appellate briefs, was not raised below, and we think it was waived. But even if the court does consider this issue, it really isn't applicable here, because again, at the time of the acts in question, at the time the contract was signed, Mr. Cantor was in fact licensed, and in Farragut, which is the primary case on this issue, the acts were done at the time the agent did not have a license. And so the court said that was illegal. You're basing your claim on an illegality, and you can't recover. And none of that situation isn't presented here. He did have a license at the time the contract was signed and at the time that the events occurred. I will jump to this issue of the personal liability of Ms. Johnson. We think, Your Honors, that it was simply a jury question. That when Ms. Johnson signed her name, not in a representative capacity, even though it was the printed form said Oak Acres Trust - Cleo Johnson, that was ambiguous, and it was up to the jury to determine what was intended. That issue was presented to the jury. It was argued that she shouldn't have personal liability, and the jury ruled. And
So was there any ambiguity as to who owned this property?
I don't think that there was any there's not any ambiguity about who owns it.
There's one owner of the property. So I'm trying to see where you think the ambiguity stems from necessarily. Yes, there's one name signed.
Mm-hmm.
Did she have the ability to do anything other than bind the trust?
Oh, certainly. I mean, although
Could have asserted that it was an invalid contract based on the fact that she didn't sign in her capacity as trustee.
not quite sure I
Well,
totally
I mean,
understood that question, Judge.
What else? Who else would she be signing for? What other entity would she be signing for?
There's certainly
Company XYZ?
no
I mean,
individually, Your Honor, and she.
why? Why would she want to individually sign that contract?
I don't know if she would want to, but the party certainly could negotiate a deal, and this is done where somebody guarantees the commission.
Could there be some language?
Yeah,
Sorry.
where's the
Could be.
evidence? First, where's the evidence?
And I'm not suggesting that there was an agreement here that there was a guarantee. What I am suggesting is that on the face of the document, there is ambiguity. It's very similar to that Schrader case from Georgia that we cited in our brief, where it was a similar type of circumstance, where the person simply signed their own name, and the court said, "Oh, this is a jury question. There's an ambiguity here, and it's up to the jury to decide that issue."
That case also involved, here, the typed line underneath, it's pretty clear. It's Oak Acres Trust, Cleo Johnson. So there's no, was that similar in the case that
Well,
you're talking about? I don't recall.
The agreement there identified the corporate. The agreement identified the corporate capacity, and the person signed individually. It was a similar circumstance. I don't have exactly what the language was, but the typewritten part identified the corporate capacity, and the person signed individually. I would even take it one step further here, though. Even the printed form, Oak Acres Trust - Cleo Johnson, that's not even clear that it's representative capacity.
Well, and that's different from the October 15th listing agreement, which didn't read that way. It said Oak Acres Trust by Cleo Johnson.
Yes, and that, I think that is a little bit more clear. But especially when you start looking at the two different documents and her signing it, I think the ambiguity has become evident. And the trial court was certainly right to send this issue to the jury and let them decide what the intent was. And Ms. Johnson can make all the arguments that she wanted and say, I didn't intend to be bound by this, and the jury could accept or not accept that testimony, but they ruled, and they ruled that it was in fact her intent to be personally obligated.
Counsel, what's the significance, if any, of the fact that she filed counterclaims against your clients?
Well, I certainly.
Is there any legal significance to that? Did she put herself? Did she invite the heir on appeal, so to speak? Did she? Can she use both ways or argue in the alternative? I guess.
Your Honor, I think you can certainly argue in the alternative, and I don't remember the exact language as to whether or not it was in the alternative. And I think that issue that she asserted individual claims, I think is certainly relevant and probably something that could have been argued to the jury. I don't know that it was, but I think it could have been argued to the jury. Ladies and gentlemen, Ms. Johnson, who's claiming now that she's not individually, filed counterclaims individually in this case. I don't think that was argued.
Okay, and to that point, I noticed in all of us, I think, were a little bit confused. In the briefing, it suggests that the counterclaims were sort of withdrawn, waived, if you will, but yet the jury, they were still provided to the jury? Can you?
Well,
give us some
what
context on
ended
that?
up happening is the counterclaims were not pursued as such, but the issues of breach of fiduciary duty and fraud were essentially then used as defenses to the case. The affirmative.
But nonetheless, the jury still came back with verdict forms that said, we find against the defendants on their counterclaims. Weren't there? No, they were not.
I don't think so.
No verdict.
I don't
forms?
think so. I didn't try the case, but
Last
from I don't think so. They were those issues ended up being at the trial were defenses.
Okay, defenses.
So.
Thank
Do you by chance have cites to the record that you can point us to where the issue was argued in terms of the ambiguity as to whether she was signing in her individual capacity? If you don't, that's fine.
I don't right here, but I've got 5 minutes left. If you want me to look and see if I have it here and give it to you before we adjourn, I'd be happy to, and I can take a look at it if you'd like me to, Judge.
Sure.
Okay. Thank you, Your Honors.
Your Honors, I have 3.5 minutes left, and that's the stack of transcripts, so perhaps we could go through it. But to clarify, the counterclaims that we filed, Mr. Thomason is correct. We did not pursue them because, as a practical matter, the real damage was there was a breach of fiduciary duty, there was a betrayal of trust, and the remedy that we were seeking was that Mr. Cantor not be entitled to a commission. There were no jury instructions given on that issue.
What issue?
On the issue of the vulnerable adult statute or any other counterclaims.
When you say we did not pursue them, at what point in the litigation did that turn then? When did that happen?
When we were, I believe, and I will say this is from memory as opposed to a statement of certainty, I believe it was when we were preparing the joint pretrial. But it was definitely made before we impaneled a jury or did anything further in that regard. The damages essentially were going to be the same, which were we shouldn't owe you anything, and that's why they were essentially converted into counterclaims. The issue.
I'm sorry, in the
no,
joint
please.
pretrial, did you put as a disputed issue whether Ms. Johnson had personal liability? Was that raised as in the joint pretrial?
I can't quote the joint pretrial, but it was certainly argued before the matter went to the jury. So it was certainly in the transcripts. And as to that issue, Your Honors, what we need to also keep in mind, Ms. Johnson signed her name. She signed it above a typewritten name and or a handwritten name, and those forms were filled out by Mr. Cantor. And Mr. Cantor also had a duty, as we've argued, to explain what it is that Ms. Johnson is signing.
And they are different, which I think arguably gives rise to the ambiguity claim. The October 15th one says Oak Acres Trust by Cleo Johnson, and the October 29th one, which is the operative one, for our purposes, says Oak Acres Trust hyphen Cleo Johnson.
And, Your Honor, as I look at both of those again, that typewritten ambiguous language was drafted by Mr. Cantor, and I go back to the general premise. I would hate to think that I waived the real argument at trial, which is she signed it in her individual capacity, so she had no authority to bind the trust. But I don't think I'm going to be persuasive in making that argument up here at the Court of Appeals. The property was owned by the trust. It was handwritten by Mr. Cantor. I mean, part of his obligation as a real estate licensee is to prepare accurate documents. So identifying who the owner of the property is, that's part of his responsibility in drafting the document.
But isn't that the argument that you would make then to the jury, that it's ambiguous, so you should hold it against him?
Your Honor, in our opinion, it was error for it to even go to the jury because as a matter of law, individually, Ms. Cleo Johnson could only sign as the trustee of the Oak Acres Trust. Escrow would not have allowed anything to close had there been a sale unless she was signing as the owner of the Oak Acres Trust. Briefly, 12 seconds, the standard for 322152 is very clear. The department has authority over licensing and regulations. 2152 specifically requires the court to make the determination of qualified, and we believe the facts of this case, the findings of Judge Fink, that when there's a violation of an Arizona real estate licensing statute, that's where the qualification comes into place. And as far as whether the illegal activity occurred previously, candidly, the illegal activity continued by his failure to disclose up until well after the time this lawsuit was filed. Thank you.
Thank you. Thank you for your arguments. We will take this. I'm sorry, counsel. I would like to give you 30 seconds if you did have something.
I did not. I know that there was a motion for new trial that was filed to discuss this issue, but I don't have the specific reference site that I can give you. I apologize.
No problem. Thank you. Again, thanks for the argument. We will take this matter under advisement, and a decision will be issued in due course. Thank you.
I said that's doing
You win some, you lose some.